Hello friends, Namaskaram. Today in the present class I am going to discuss the important judgment of Honorable Guwahati High Court, which is quite recent, in which the concerned NDPS offender was acquitted from the charges on the ground that there is major inconsistency in the testimony of the concerned prosecution witnesses, and apart from that there is nothing incriminating on the record by the virtue of which we could say that the concerned accused has committed the crime. Got the point now? The judgment was passed by Honorable Guwahati High Court. Mani Nuth versus State of Assam is the name of judgment, and it has been pronounced on 9th of September 2024. In this case, the accused has been charged with Section 21 subclause C of NDPS Act, read with Section 25 of NDPS Act, and finally he was convicted by the concerned trial court with rigorous imprisonment 10 years, and also fine of rupees 10 lakh had been imposed. The case of prosecution is that on 28th of September 2021, the concerned SI had submitted the report to the concerned SHO. He submitted that at 2:30 AM he received an information that a person is going to deal with drugs and psychotropic substance. He found the information reliable and finally rushed towards the spot, and before moving the same, he inter alia intimated the matter to the concerned circuit inspector and obtained the requisite permission as per the protocol of Section 42 of the NDPS Act. Finally, the raid was conducted, the alleged article had been recovered, and FIR has been registered, accused has been charge sheeted, and finally the trial proceeded. After having the complete trial, the concerned trial court found the accused guilty and convicted the accused accordingly in the manner I told you earlier. So it is a basic scenario, because for the prosecution under the NDPS Act, the concerned prosecution is required to specify only two things. Number one, you are in the possession of psychotropic substance and narcotic drugs, and apart from that you are not having any authority to deal with in the same. Means while doing sale, possession, transfer, you are required to obtain the permission, that is called license, from the authority. If it is not available and you are in the conscious possession of the contrabands, in that scenario it is sufficient for the prosecution. Friend, while assailing the order, the concerned defense submitted that the concerned trial court totally failed or ignored to consider the real circumstances available on the record, and there is nothing incriminating, and apart from that there is a major inconsistency in the testimony of the witnesses. He submitted that PW1 is the prime evidence. He was called by the police at the residence of accused. He submitted that the door was locked, it was knocked, accused opened the door, and certain cough syrup and expired medicines has been recovered. The primary key is that the alleged articles or contraband has been recovered from the cartoons, and he totally failed to remember the exact number of cartoons, and he also failed to specify the total number of articles in the specific cartoons. As we know that there are certain persons who used to do drug sale or psychotropic substance sale not on the individual basis but in consequence of medical license usually given to them as per protocol of form number 21B of drugs and cosmetic rules 1945. But when the license expired or they failed to account for the same, and apart from that they store the drug in the premises wherein license is not given, in that scenario while doing the raid, the concerned authority presume that the concerned persons are involved in the concerned crime. So in that scenario this citation is quite helpful for you, because in this case the case is not that the ganja or any other contraband in the raw format has been recovered, but the case is that certain medicines or certain expired medicines has been recovered from a cartoon, and that's why prima facie it is appearing that the case is concocted and the entire case has been targeted as evident from the record. And apart from that, the another witness, that is PW2, he belongs to seizing of article. He submitted that the list so prepared was not shown to him, and apart from that he has not attested any such list. That is also a plus point in favor of defense, because list is required to be prepared, and apart from that when sample is going to be drawn, the list of sample list is also going to be prepared and requested by the concerned magistrate. If these protocols are not done, in that scenario the situations are in favor of concerned defense. Apart from that, PW3 is a traplaying officer. He submitted that the alleged articles are cough syrup, it was seized, FIR has been registered, the copy of seizure report has been immediately submitted to the concerned superior officer. But the key point is that he totally failed to comply with Section 52A of NDPS Act, which mandated that when sample is going to be drawn, it is to be drawn in presence of magistrate. Apart from that, the consent letter containing the list of sample drawn is required to be prepared, and it is required to be attached by the concerned magistrate. If no such protocol is done, in that scenario, section 52A of the NDPS Act is violated. But in the counter, the consent prosecution submits that the sample has been drawn in presence of magistrate. Even the letter to forward the sample to the concerned CFSL was prepared, and the said letter was submitted to the concerned CFSL through SP office as well. And apart from that, the seized articles list has been prepared, even photograph has been taken, even they are countersigned by the concerned magistrate, even certificate regarding the same is enclosed. But the key point is that the version submitted by the concerned agency is not supported by any co-agent or direct evidences, and they totally fail to note down the number of persons available during the trap proceeding. And apart from that, the concerned register of Malkhana was not on the record, and in addition to this, the said list submitted by the concerned TLO was not on the record to sustain the compliance of section 52A of the NDPS Act. So the court considered the said scenario also fatal and against the prosecution. Apart from that, punch witness turned hostile, and apart from that, they submitted that no article, even list of seized article had not shown to them. The concerned CFSL report submitted that the concerned article contained contraband, but the key point is that the report is totally failed to mention the batch number of sample to which sample belongs, and even IO failed to comply with section 52A of the NDPS Act because there is nothing on the record in which manner it has been complied with. As we know that the protocol is required to be followed. If the protocol is not followed by the concerned prosecution, in that scenario the accused could have the benefit. We are in rule of law, and rule of law contemplates that everything is required to be followed. It is the duty of the concerned IO or officer in charge of the concerned PS that the said procedure is required to be complied with. Means when the magistrate draws the sample, the list of samples so drawn is required to be prepared, and it is required to be certified and attached by the concerned magistrate. The same is also requirement as observed by Honorable Supreme Court in case of Union of India versus Mohanlal. Judgment is pronounced in the year of 2016, and apart from that, we are having three recent judgment: 2023 named as Bohilal versus NCB, Simranjit versus State of Punjab, Yusuf versus State. In this judgment, it is observed that the consent sample is required to be drawn as per section 52A of the NDPS Act. Apart from that, NDPS seizure, storage, sampling, disposal rules 2022 is also important, but there is nothing on the record to show that the said protocols had been complied with while drawing the sample. Apart from that, the chain custody of contraband is mismatched because the Malkhana in charge and Malkhana register is not produced to verify the said fact. And apart from that, there is inconsistency in the statement of the witnesses. Some is giving different version regarding the seizure and the contraband recovered, even regarding the place and the mode of seizure. And that's why, looking to the facts, circumstances, inconsistency, the court observed that there is no compliance of section 52A of NDPS Act. Apart from that, while doing the seizure, the NDPS seizure, storage, sampling, disposal rules had not been followed. Chain custody is missing, Malkhana register is not produced and exhibited, and there is inconsistency in the statement. So finally, the accused was acquitted and the charges has been exonerated. So the judgment is not a mere judgment, it is providing us the 5 guidelines to be borne by us in our mind while contesting the case under NDPS Act. First thing is that we have to chalk out our role, the role of accused assigned to it under the present case or the case under which he is booked. Okay, now number 2, we have to see the compliances which are required to be done, whether these compliances had done or not. Number 3, the timeline event. Number 4, the method to approach the concerned accused, means all the time consuming timeline is required to be drawn so that we could convince that this is not a case but a fabricated case. And last but not least, we have to emphasize on CFSL report the total quantity of sample drawn, the total quantity of sample or article present, the manner of weighing. Apart from that, the total article deposited in the concerned Malkhana and total article quantity remained after the same. So these are the protocol which are required to be borne our mind. Rest, there is nothing to worry about.